You could be 5% at fault in a Maryland crash and walk away with absolutely nothing. No payout, no coverage, no help with your medical bills. Because in Maryland, contributory negligence doesn't reduce your claim, it kills it. In this video, I will show you how to protect your case even if an adjuster says the crash was partially your fault, so you don't get tricked into giving up money that you are legally entitled to claim. Hi, I'm Bobby Zirkin. I'm an attorney for over 25 years here in Maryland. I've been a member of the Maryland House of Delegates, the Senate. Let's jump right into this. Here's a rule that trips up a lot of good cases. Maryland uses what's called contributory negligence. We're only one of 3 states that does in the entire country. If a judge or jury decides that you were even a little bit at fault, and that fault helped cause the crash, your bodily injury claim against the other driver will be barred. It could be 0. Not reduced, but barred. That is different from the comparative systems you read about in most articles online and see in most states, where being 20% at fault, for example, still means you can recover 80%, 50-50. There are states of all levels doing comparative negligence. Like I said, there's only 3, including Maryland, that has contributory negligence. Maryland's highest court reaffirmed this really bad rule in Coleman versus Soccer Association of Columbia in 2013. The court was asked to adopt comparative negligence. It declined and left contributory negligence in place. What that means in real life is that the word partial takes on an outside meaning. Adjusters and defense lawyers know that if they can tag you with any legally significant share of fault, no matter how small, they can try and end your claim. Here's the good news. Fault is not a feeling. Fault is a legal conclusion tied to evidence and causation. You can make a human mistake, but unless that mistake amounts to negligence under Maryland law and actually help cause the collision, it should not bar recovery. I spend a lot of time separating harmless errors from legally meaningful negligence so that a judge or a jury can see the picture clearly. Traffic rules matter, for example. Violating a statute is strong evidence of negligence. In fact, violating a statute in Maryland is negligence per se. If the other driver ran a red light or failed to yield, that supports liability, obviously. If you think you were going a few miles over the limit or missed a signal once, the key question is whether that conduct played a role in the wreck. If the answer is no, then contributory negligence should not apply, although the insurance companies will try. Small errors that did not affect the outcome do not defeat a valid claim. One more point before we move on from this. A liability claim is only one piece of the recovery puzzle. Even while a contributory negligence argument is floating around, you may have benefits that do not depend on fault. I will explain these in a moment, because understanding them takes a little bit of pressure off and gives us time to build the case the correct way. The narrow doors that still let claims move forward. Even with contributory negligence in Maryland, there are narrow but real routes to recovery. First, there's the last clear chance doctrine, which allows a plaintiff to recover if the defendant had a new and clear opportunity to avoid the harm after the plaintiff was already in a position of peril and failed to use reasonable care to do so. An example, a driver sees a stalled motorcycle ahead with ample stopping distance, yet looks down at a phone and coasts into the rider. Even if the rider had made a mistake earlier by kind of staying out on the road, the driver had the last clear chance to avoid the harm and he failed to use it. Second, willful or wanton conduct is treated differently from ordinary negligence. When the other side acts with conscious disregard for safety, like a drunk driver who chooses to drive or a street racer blasting through an occupied crosswalk, the law is not going to let that behavior hide behind your very minor lapse. Maryland courts have long recognized that the most reckless conduct should not escape accountability because a victim could have been a little bit more careful. Third, causation matters more than labels. I often see partial fault arguments based on modest speeding. Suppose you were 5 miles over the limit with a green light and a truck turned left across your path, leaving no time to react. If the crash would have happened at the posted speed anyway, your speed did not help cause the collision. In that scenario, contributory negligence should not apply because the negligence that mattered was the left turn across your right-of-way, not your speed. Fourth, Maryland statutes set boundaries on blame. The transportation article at 22-412.3 says a failure to wear a seatbelt cannot be used as evidence of negligence or contributory negligence and cannot be used to reduce damages. When an adjuster tries to hint that your injuries are your fault because you were unseatbelted, that suggestion is off the table under Maryland law. Finally, look at your own policy. Personal injury protection, or PIP, under Insurance Article 19-505, pays medical bills and a portion of lost wages regardless of fault. PIP keeps families afloat while liability is in dispute. Collision coverage can repair your car now rather than waiting for the other carrier. Uninsured and underinsured motorist claims usually require that you would be legally entitled to recover from the at-fault driver first, so contributory negligence can defeat those, but PIP stays available. How to talk to insurance when partial fault is alleged. If an adjuster says you were partially at fault, do not panic and do not argue. Think strategy. Keep your statements measured, short, and factual. And in fact, it's probably best don't talk to them in the first place. Just call a lawyer and let us do the talking. But if you do end up on a telephone call and in a conversation, just remember, explain only what you saw, what you did, and what you felt, and then stop. Guessing at speed, guessing at distance, guessing at time creates openings for a contributory negligence argument. If you don't know, don't say. You are allowed to be careful with your words, and again, it's best never to speak to insurance adjusters. Let your attorneys do the talking. Lock down the evidence early. Photos of the scene, skid marks on the road, resting positions of the cars, debris fields, and vehicle crash angles all matter. So do call logs, dash cam videos, nearby business surveillance, event data recorders. All of these are things that we're going to go get. The sooner you and your lawyer requests and preserves those items, the less room there is for an adjuster to paint a vague picture that somehow shifts the blame to you. A clean timeline supported by objective data takes the sting out of the word partial. Focus on the traffic rules that actually apply. I often hear someone say, I could have done something different because it would have been safer. Safety is always good, but liability turns on specific duties. A driver making a left across oncoming traffic must yield to vehicles lawfully within the intersection. If that duty was violated and your conduct did not contribute to the crash, comparative language about what would have been safer is just noise. Keep the discussion grounded in the rules that govern the situation. Do not let the seatbelt issue distract you. Maryland law blocks seatbelt non-use from being used as evidence of negligence. It can't be used as evidence of contributory negligence, and it can't be used to reduce your damages. If an adjuster brings it up, shift the conversation back to the actual cause of the crash and to your damages supported by your records. Use your no-fault benefits smartly. Submit your medical bills to PIP. Submit your car repairs under collision if you have it. This reduces stress and keeps you mobile. It also gives your lawyer a little bit of room to build the liability case without the financial clock ticking loudly in the background. How we build winning cases and what to do next. When someone comes in worried about being a little at fault, we run a very disciplined process here. We start with a story, test it against the physical evidence, and make our determinations. We measure, diagram, and study damage patterns, and we request intersection timing data, lighting conditions, and sight lines. If visibility was limited by a design flaw or a line of sight obstruction, we explore whether a property owner or a public agency played a role. We make sure the records connect the dots with clear onset, consistent complaints, appropriate treatment, and objective findings. That credibility helps when we explain that the other driver had the last clear chance, or that your small mistake had no role in causing the collision. Be precise and be truthful. If you don't remember, say so. This goes for depositions as well. You are not supposed to guess, only the facts. Pivot to what the other driver did or failed to do. Jurors respond to accountability and to fairness, not to finger pointing. They do not punish people for being human, but they do hold people responsible when the evidence shows who had the power to prevent the harm and failed to use it. So again, be honest and open and don't guess. Contributory negligence is strict, but it is not the end of most cases. The law still asks about causation, duty, and opportunity to avoid. While that unfolds your PIP protection, or your PIP benefits, and your collision coverage can keep you stable. If an adjuster is pressing partial fault or contributory negligence, get guidance before any broad recorded statement. Again, get legal guidance before you make your recorded statements. Preserve evidence. Be mindful of the 3-year filing deadline that's contained in Courts and Judicial Proceedings Section 5-101. Now that you understand how Maryland's contributory negligence law works and the strategies to protect your claim, there's another critical piece of the puzzle: getting the right medical attention at the right time. Your medical decisions in those first hours and days after an accident can make or break your case, and more importantly, your recovery. In my next video, When Should I Get Medical Attention After a Maryland Car Accident?, I will walk you through the medical choices that strengthen your claim, the red flags that insurance companies look for in your treatment records, and the timeline that actually matters when you're hurt. Thanks, and I'll see you over there.